The idea for this panel emerged through a collaboration between the Hooks Institute and the School of Urban Affairs to take action on an issue raised in one of the 2019 Hooks policy papers that focused on the detrimental effect of land installment contracts on African American homeowners. Over the last year, we have been working with a group of community development organizations and faculty to better understand the pervasiveness of the issue in Memphis and to advocate for policy changes. In the process, we came to understand that land installment contracts and other forms of contract for deed are not necessarily very well understood. Thus, we wanted to bring together two groups that work on the front lines of housing, specifically code enforcement and community development professionals, to talk about how to identify these types of contracts, what they mean, and how they impact local home buyers and neighborhoods. So thank you for joining us today to learn more about this. Before we get started, I'd like to introduce our speakers. First, Brittany Williams is the Code Enforcement Prosecutor for the City of Memphis. She's a graduate of the University of Memphis Cecil C. Humphreys School of Law, and she's been tackling blight in Memphis for many years. She served as Memphis' first City of Memphis Neighborhood Preservation Fellow in 2016 and continues this work today in her role working with code enforcement and public works on code enforcement prosecutions. Second, today, Charia Jackson, who is the Deputy Director of the Frayser CDC. She has a long history of working with residents of the Frayser area in achieving and sustaining home ownership for their families through the agency's HCD certified housing counseling program. Throughout her tenure in community development, she's been listening to the housing needs and issues of moderate income households and has been working to solve those problems through policy advocacy and programming. And our third speaker today is Mike Fernley, who is an attorney with Apperson Crump Law Firm. Like Brittany, he too is a graduate of the University of Memphis Law School. He's a member of the Memphis and Tennessee Bar Associations. Mr. Fernley specializes in real estate law and has 25 years of experience with diverse types of real estate contracts and transactions. He teaches homebuyer credit counseling courses locally and as well as teaches for the National Association of Real Estate Brokers Education Program. Thank you to all the panelists. I will turn it over to them now. Please know, for those of you who are tuning in the audience, we will have time for Q&A after the panelists speak, so please feel free to post your questions in the chat box. So I'll now turn it over to Brittany Williams to say a few words.
Thank you, Catherine. Thank you to the U of M and the Benjamin Hooks Institute for putting this on and doing this very needed training. This is important because with code enforcement, one of the first things that we look at or we try to figure out is who's responsible for the issues at a property or the violations that are occurring. And with these land installment contracts, that can be pretty tricky. Is it the tenant or is it the actual landowner? So for everyone that's involved with code enforcement, if you have any questions about what's presented or how do we move forward, just let me know. We are developing a process for how we can keep track of this information and make sure the right people get it. So thank you for having me.
Thank you so much, Brittany. We're gonna have now Charia Jackson talk a little bit about her experiences working with home buyers and home owners who have land installment contracts.
Hi, thank you. Thank you to the Ben Hooks Institute and the U of M for allowing me this platform to speak on land installment contracts and why it's important that we educate consumers on what these contracts are, what they consist of. I guess I want to start out by talking about why this is such an important conversation, because in working with homeowners or potential homeowners, it's important that they understand exactly the equity involved in the home ownership. So from our experience, we're seeing these contracts that represent some level of ownership, but I think it misrepresents exactly what we all know home ownership to be. So it's important that we educate consumers about these contracts. So to give you a little bit background, the Frayser CDC, we're housing developers working in the Frayser neighborhood here in Memphis. And over the years, we have spent time developing housing and also developing homeowners to be successful at their home buying process to buy those houses that we develop here in the community. Also, we spend time working with current homeowners to address home ownership and home ownership, preserving themselves in home ownership. Last year in 2019, we did an initiative to try to increase the home ownership rates here in the Frayser community by doing an outreach to renters in the community to encourage them, to think about home ownership if they hadn't already done so. From that initiative last year, we were able to work with some tenants who had some contracts that in their mind, they thought they were already buying the house, but they came to us to seek some level of advice about the contracts that they had. Those contracts, in this case, it was a residential lease with the option to purchase agreement. And they also had a level of calling it a triple net lease. All this was emboldened on the contract. That particular contract was not what the residents thought they were in. They thought they was in a position to buy a house 5 years from the date they entered the contract. And the goal would be to buy the house in 5 years, build up equity by paying into this contract with the current landowners, and then eventually purchase the house 5 years later. Or they can do an owner financing with the landowner 5 years later. So just to profile the individuals that we worked with on that day, this was a married couple who had a household of 4, making about $41,000 a year in income. Their idea of purchasing this house came because they didn't have the credit at the time, and then the landlord, presented them with this opportunity through this contract. They had a contracted sales price to purchase this house at $55,200, giving it a price for that 5 years later from the time they enter into the contract. They had a monthly house payment of about $595, I believe. Of that $595 monthly house payment, a portion of it was going towards the property taxes that belongs to the house, the landowner. A portion of it was to pay for the renter's insurance. And then another portion of that $595 payment was to go towards non-refundable credit towards the purchase of the house. So given if they decided not to buy their house in 5 years, that $70 per month for 60 months was no longer going to be money to them anymore. In working with these clients, our goal was to help them buy the house or work with them to figure out how they can achieve home ownership, because clearly the contract that they were in was not what we teach or educate people about traditional home ownership or ways to enter into it. We found that these tenants were so unprepared in knowing that the contract that they had them actually maintaining the home, making major repairs, the types of repairs that landowners should be responsible for. And just remembering some of the types of repairs that they were spending out thousands of their hard-earned money to keep this house up. There was plumbing issues. If I remember correct, they had like a water tank issue that led to flooding, that led to some other structural issues, but they were responsible for making those repairs there was some electrical problems, but no tenant should be responsible for the maintenance and upkeep of major functions in a home. And here they were unable to get the credit they needed to get because they were spending money to maintain someone else's house that they thought they were actually buying. It's just sad. We just find ourselves really want to point out specific elements within a contract that consumers or tenants in this case should pay attention to. Some other details about this particular client profile. It was a 5-year lease, right? And if they were not able to obtain a loan in those 5 years, the landowner offered them owner financing of about 10.99% interest over 25 years. When you add up that level of cost of a house that's in substandard condition and tenants who don't have the credit to actually get financing of their own, it's just like it's predatory in all the reasons. They're putting them in a house, telling them this house can be yours, you can buy it from me. You just put all your hard-earned money into this house over the next 5 years, and of course, if you didn't have the credit then, and you will hope they will work towards the credit. But how can they work towards that credit if they're actually trying to fix, the HVAC system in the house, or fix plumbing issues or things that the landlord was responsible for? It's just one of many sad stories that we've heard as we work with consumers on dealing with housing issues. And from our seat as housing educators and counselors, we find it important to point out the details of those contracts. So I'm here today to just leave you guys with information. If you're coming across any consumers who have these types of contracts in hand, get them in front of a professional like a housing counselor, such as, Frayser CDC, and there are other housing counseling agencies around the city where they can speak with someone who's a little bit versed in understanding exactly what they're actually dealing with and how they can overcome the issues of a contract like this and really put them on the goals to home ownership in a better way than actually paying these higher costs in these types of contracts. So it's going to take professionals like us, everybody on this call today. If you're coming across these, let's educate the clients and find out that it is important that we spend time just pointing out what makes sense to call a lease purchase contract. How do you get them to actually eventually buying the home and not put themselves in predicaments like this where it feels like they can never get out of this, because even if they decide to buy in the near future, what are the chances that their house will appraise if they're spending, a lot of time actually patching up the house just to live comfortably? That's all for today, but it is important for people in this industry really to work with consumers who probably was just in a position where they needed a house and it was easy to enter into a contract that made sense, but it's the level of actually knowing the details in the contract and what the cost of actually living there, and if it is really home ownership. In this case, there's no equity here, and they thought they was on the road to home ownership. That's all I have to add for today. Yes, thank you.
Thank you so much, Charia. Now we're going to turn it over to Mike Fernley to talk a little bit about some of the legal components related to these contracts.
Hello, everybody. I was going to draw others. My partner at Apperson Crump in the real estate department wanted to jump on and take the first question. So if that's okay, he's going to.
Well, the first thing is talking about contracts to purchase, leases to rent to own, or lease purchase agreement. And to start with, let me tell you a little bit about ancient English common law. It's not that boring, but we'll start with this. There's a difference between a contractual right and an interest in land. an actual ownership interest in the land. Now, the simplest thing they start with is a contract for purchase. This, whether it's just a 30-day contract for purchase to be purchased at the end of that, or whether it's a 10-year contract to purchase with an option to purchase at the end of it, what you've got during that contract period is only a contract right. You don't have any interest in the land. There is one exception in that case, but I haven't seen it used in a long time, called equitable conversion. But really, you don't own the land. All you've got is a contractual right to buy it. If the guy fails to sell it to you, you may have the option of specific enforcement, which will make a court of equity turn that land into your name. But, you know, in general, with a contract to purchase, you have the least interest that you could have and no interest in the land. On a lease purchase, where you have a lease term and an option to purchase at the end of the lease term, you at least have a leasehold estate, which is a recognized interest in real estate. So you have something to hold on to during that leasehold period. And that is why, if you have a lease, if you have a contract, you can declare the contract in breach and simply go to court and enforce that, or cancel it and let the renter go to court. But if he has a lease interest, you have to enter into a forcible entry and detainer lawsuit, which has to dispossess him of that interest that he has in land, because an interest in land is much more important or much more valuable than a contractual right to buy the land. Of course, then, if you've got a standard mortgage, what happens in that case is that you actually get title fully to the land, and you own the entire, what's called a fee interest, as opposed to a leasehold interest. And once you own that fee interest, you cannot be dispossessed by that just simply because of a deed of trust being put on there. What they have to do is go through all the procedures of foreclosing your right of redemption under that ownership agreement. And of course, that's the way, you know, people with means and credit, sufficient credit, normally go about buying a house. The other two events are done when people don't have the credit rating or don't have the ability or the down payment, you know, to buy the house now, but they would like to go on and try to build up some money of their own during the contract period or the lease period, whichever one you do. Now, what we would like to see more often, especially for the tenant side, is a lease purchase rather than a contract to purchase, because at least you've got a forcible entry and detainer suit that they have to go through, and you actually have an estate in the land, leasehold estate. Under the deal like that, usually, if it's a lease with an option to purchase at a certain price, a lot of times the payments would be the same as they would be on a mortgage. It's based on current mortgage rates, and that's a little more than what the value of just a straight lease with no option is. And the option of that is to go ahead and actually put a little equity down into the lease. And although you will lose it, if you've reached the lease, you know, you say you quit paying altogether, and they come in and do a forcible entry and detainer, you still lose your money that you've had there, which you would not do in a case with just a straight mortgage. Because when they do the foreclosure and when it sells at foreclosure, the lender only gets his amount of money back out of it, and plus whatever interest has not been paid. You still get the equity in it. Lease purchase and contract to purchase, not so. Now, when you talk about who's responsible for each item under the lease purchase and a contract to purchase, that's done by contract. If the contract says that, if you're doing a contract to purchase, it says the leasee is to pay all of the taxes, all of the insurance, and all of the
Make all the repairs.
make all the maintenance. Yes, if it's triple net like that, what happens is you have to look carefully at the economics of that. And I think Charia was talking about how, well, for example, when she mentioned a $55,000 purchase price, but rent at $500 and something a month, that's a 10% per annum payment, which is a little above lease rates and probably even triple net rates. And that has to be looked at carefully before you do something like that. Let's see, another item that occurs to me that is in the contract to purchase, excuse me, and in the leasehold state, whoever is given the obligation to do the maintenance and to keep the property from going into a receivership, it does not matter to the courts because when they enforce a condemnation or they enforce a tax sale or they enforce a receivership for blight control or something like that, it's only an action against the land itself. The state, as the sovereign, has the power to repossess land. Almost, it's akin to the king actually deciding that some tenant, some subtenant, some earl, count, or even a baron has breached his obligations, and the king can come and take it back, all the way back to him. So the state has that same power in forcing a receivership or forcing a condemnation, but they don't have what you call in personam rights against anybody. And the reason why the landlord and the tenant are interested in that is while they don't have any personal obligation to upkeep the property vis-a-vis the state, if you're under a lease purchase agreement and the owner is supposed to keep the property in good condition, and if the state comes and says this is in terrible condition, it's going to be condemned or go into receivership, then the landlord will have breached a covenant of what they call quiet possession under the lease. You won't get that under a contract for sale, but you do have a covenant in a lease where the landlord is deemed to have said, much as in a warranty deed, as long as you do what's in the lease, you will maintain quiet possession throughout the lease term. Once that doesn't happen, if the lessee has been doing everything he's supposed to do, the landlord has not, and it's taken away, the lessee has a cause of action for breach of the warranty of quiet possession in that case. But still, if they're coming to get it in the lease, the landlord's still going to lose his land. So he's motivated to get out there and do the repairs or do whatever he's supposed to do, because he doesn't want to both lose his land and then get sued for violating the covenant of quiet possession. So that's usually the way that part works.
Well, let me flip in for a minute, Joe.
Yeah.
One of the key areas that I think is very concerning is when the amount of money put down as the option money doesn't have any bearing to the amount of time some individual will have to buy that property. And for example, if you put down $5,000 for a 2-year option, that's not realistic to me, and that somebody should never do that. That's an unfair probably transaction, especially on a lower end property. Now, if you put down $10,000 on a 10-year lease, and here's where I think you have a little bit of an advantage is you have to have in your lease purchase or your lease option agreement the verbiage that said you have the right to sell that property anytime during your 10-year term, and that the owner will be entitled to the amount that he has agreed to sell it for, and you as the buyer, leaseholder would be entitled to the proceeds over that amount. So it's much like an owner finance deal, but that has to be very specific language put in your lease purchase or option agreement. And unfortunately, we don't find it in as many as we should because we see these people that, you know, literally they're probably coming out of a foreclosure or a bad eviction. Their family may pool together some funds to help them get another property, and that maybe the only option they have at this point is a lease purchase, or that's all they think they have. And you know, we all agree that they should go get credit counseling. They should go to get house counseling from an FHA counselor. But we know a lot of times they don't know this, and this is one part that maybe we could help publish out there is, and I think goes with the lawyers, is never sign any agreement, lease purchase, option purchase, whatever purchase, without letting the lawyer look over it. One of the key things we do here, and it was very important to us, is you never want to enter into an agreement with somebody that you don't know owns the land. So in the pure closing practice, there's going to be a title search performed, and we're going to find out if the guy that owns the property, what he owes on it, whether he will be able to sell it to you in a lease purchase contract. And that's, to me, that's number one key. We don't want to sell a property to a man that has we don't want to buy a property from a man who has federal tax liens or judgments or a large mortgage on the property, which he will never be able to pay off, even though you may have paid off your end. So that's the number one key, I think, is making sure you have somebody check the title out. And then the other thing that we, you know, the market's changed, interest rates have changed, but these are still governed by the federal, not the federal, but the state usurious statute, which means they, at this point, I think it's 7.78 or something.
It's 4 over prime.
It's 4 over prime. So the amount of money that the lease purchase collects in over and above what the normal payment would, if it exceeds that 8%, then it's out of balance with the state statute, and that could bring some eyes to look at that. And I'm not to say prosecution, but they may come in and make them redo the loan, or they may stick them with the penalty. And we say that to the you know, an individual can go up to 5 lease purchases on his own, but anything over that, they're going to be considered a mortgage company, and then they have to comply with the mortgage statutes, which were much more stringent than the kind of lease purchase statutes that are out there.
It's one of the reasons why a lot of the people like lease purchases, because like I told you, the lease payments are supposed to look like mortgage payments on a regular mortgage. But if you stick the rent up, and this is, as a matter of fact, how under Charia law, where they don't allow for a collection of interest in the Arab countries, what they do is they do a lease purchase, basically, and if they do that, the lease amount, the rent amount, is not considered interest, at least under Charia law. But even under, you can see that even under regular American law, you can stick that rental rate up as high as the two parties agree to it. I mean, you know, in the case cited earlier, you know, it could have been $1,000 a month, and it wouldn't violate the usury laws. But if you had a note for to pay for, you know, a $55,000 house over 10 years, and the rate was whatever that is, well, I guess it was close to 10%. That would violate where we are right now on the prime rate. So that does make a difference. And one thing Mike said that also is important is, you know, we do the title search and make sure that he doesn't have a mortgage on there, but it's important to know that this isn't a mortgage that covers future advances, because if you look at that mortgage and you get a estoppel certificate and find out it's, you know, you're buying a $55,000 house and it's got a $30,000 mortgage left on it, but it's got after a future advances clause, and it's recorded before your lease, then in that case, if they make those future advances, you've still got to pay off. You've still, you know, when you get your option, if your option price is not enough to pay off what he's inflated the mortgage to, it's not going to do you any good, because the bank will be able to go ahead and either say, pay me off, you pay me the rest of it, or we'll foreclose. So,
and unfortunately, very frankly, the landlords are bidding against the tenants being able to make all the payments under this lease, because that's why they're generally, individuals are generally not set up to be banks. They don't have the money to leave out there unless the return on their money is better than it gets in a bank. And for that reason, they go out and buy these properties and lease them out, or lease purchase, option them, or different, contract for deed. They go these different routes. But let's go back to the code enforcement side of this. When a code enforcement approaches a property that appears to be under a lease purchase, going back to Joe's analysis, the property owner is always responsible for the condition of the property. Now, he can have a contractual agreement with a tenant that the tenant's supposed to do it, but if the tenant breaches that agreement, he's breaching it with the landlord. He's not breaching it with the city. So in that case, you'd always want to make sure you give the summons to the landowner, and that becomes a little bit difficult if the landowner is in California or not in state, but he's still the proper person to get it. I don't think it hurts to give it to the tenant or the lease purchase or the lease option person, because it does one of two things. It gives us a chance to get him into court and maybe see what his predicament is, so maybe we can help him get out of it or negotiate something a little better than he already has. And that's why I'm high on giving it to everybody. And also you may find out that you never know. Sometimes we find out an owner's dead, and he hasn't been doing what he's supposed to be doing, and you're still sending your payments in, and the gentleman that sold you the house who's retired in Florida is no longer there, or did the lease purchase with you. Maybe this is his third lease purchase. We see that kind of thing turn over. But going back to the deal, you've got to talk to your attorney or a real estate agent or your credit counselor, HUD certified credit counselor, one of the nonprofits that are dealing with helping folks get into rental properties and build home ownership, because while it may give you an opportunity to buy a property, and let's say probably 15 or 20% of these deals actually work. That means 80% of them didn't work. That's a high number, and that's just a guesstimate. But we see them not only in one area of the city, but we see them all over the city. I mean, you could be out in a high dollar suburb or right in the center of the city. It doesn't seem to matter. And we also see them in commercial buildings. So they're all over the place. But the one thing that governs the interest rate is the usury laws, and that to a certain point makes it so they can't be overcharged, or they shouldn't be overcharged when they go in there on setting up their rate to their payment and their rate and those kind of things.
If you, I noticed that one of the things they asked was, how can you tell a contract for purchase from a rent to own or a lease purchase? Well, it's both of them probably have the same looking option on the end. It just says, at this date you can buy this property for so much dollars if you give me notice 60 days before. They both have that on the end. The difference is you'll have to look, but a contract for sale won't contain the word lease. It just simply says that I agree to sell to you and you agree to buy from me this property. A lease will say, simply, the landlord hereby leases and the tenant hereby rents the property, hereafter described. Terms in there can be almost the same, almost identical. The economics, you'll probably pay a little bit more under a lease purchase than you will under a contract purchase, but you've got, like I said, you've got a great deal more protection in that. And other than that, I'm not exactly sure that there's anything that's very different. The contract terms and the economics, other than the fact that you're paying a little more, are pretty much the same. But you're paying more, one, for the extra protection, and two, as kind of if you've got a long-term lease purchase, that option price is going to be, the property value would probably be greater than the option price. So there's a kind of like a halfway amortization in there of it, sometimes full. Like I said, a lot of times the monthly payment under a lease purchase will be pretty much equal to what a mortgage payment would be on the same property.
One other thing in the questions we had text to us, and this is, how can you record a lease purchase contract? To record any document at the registrar's office, it has to be notarized, and the parties' signatures have to be acknowledged. So that's number one, and so it has to be a notarized document. And number two is it has to have the transfer tax paid for the amount of the purchase that's shown in the contract. So if you're buying a house, you'd have to pay, you know, let's say transfer tax is $400 or $500. You have to also pay and have the deed registered with having paid the full tax, and that hurts a lot of small time folks who just barely had enough money to purchase, you know, just get the lease purchase down, deposit down, and we're telling them to record their contracts, and it's a great idea, and it really should be done. But if they don't have the funds to do it, they're not able to do that, and so that's something we need to make them more aware of, because the title search and recording that title probably protects them more than anything that we can do for them. And counselors, or like I said, any of us can help do that or direct them to the right people to do it, and each one of us can play a different role in making sure they're protected. And I guess that would be our hope at Apperson Crump, is that, you know, we can play a part in fighting off this, fighting off these bad deals and helping people get into good deals. So we'll turn it back over to the moderator.
Great, thank you so much. I will open the floor to some questions that come through in the chat box. I did have perhaps either of the panelists could talk a little bit or say something a little bit about how big of a problem do you think land installment contracts are in Memphis? How pervasive?
I like to add.
I'll give it a try. How big a problem is it? I don't think it's a huge problem, but I think it is definitely a problem in certain neighborhoods. We see in our office people coming to see us. A lot of Hispanic people seem to be kind of, because of the language barrier, in part taken advantage of, and also, you know, it's like in Frayser or anywhere else. There's a certain percent of the people that have come out of a bad situation, and they're just primed to be a victim to this, you know, move in with a little bit of money, because, as we know, most of us, if we're in trouble, our families would rather help us get a down payment than have 10 people in the house with them. So it seems like people are able to scratch up down payments to get this little deals done, and that's, you know, but to me, there's a certain number of those that are just wrong, bad deals that should have never been done. And I think there's a certain percentage of them that may be a fair deal, maybe not the best deal they should have got or could have got. And those are the people I think we ought to be looking to rescue while they're still in that agreement. If that's the house they want to buy, maybe fix it where they can buy it, or let them know what the situation is so they can move on and quit making, you know, ridiculous payments until they can save their own money up so they can buy a house and get in the program. Because even like with the Frayser, the programs, you get people in houses for $500 sometimes. I mean, for very minimum prices. So there's options for people. They don't have to do this.
No, I was just going to add, there have been times where we have promoted programs that was specifically for homeowners. Take it back to the year that the windstorm came, and there was a lot of need for roof work to be done in the community. So we did some outreach. We had a lot of people coming to us thinking they were homeowners and they had legitimate ownership rights to this program that we were only offering for homeowners. So it was at that moment we too knew that, oh, these people, they don't know that they don't own the house. You know, they're not legally the one that should be here asking us to fix the roof on the house because of the windstorm. And in their minds, they were the homeowner because they had some contract in place, whatever, you know, different names for them, residential lease, lease to purchase. But for them, they didn't know that it didn't give them the legal rights to owning the house, but it was some type of agreement that they had in place to eventually be the owner of the house. So again, it's just important, the knowledge of us, really pointing out to residents what these contracts are. And there's just that, and them knowing if they're a true owner or if they, have a contract in place for future ownership. And the fact that with that particular program, we weren't able to help a lot of the people who came to us for assistance because they had those contracts in place and they weren't, the legal owner.
Thanks, Charia. We've had a question come in for Joe and Mike. Could you clarify and say again, who records the lease purchase contract? Can the landlord do it, or must the renter/purchaser do it?
The answer to that question is either one can record it, but the probability is the person with the money would be the buyer, or the lessee would be the one that would have it recorded, simply because they're having to pay. They're generally in the contracts. The other one are going to pay the transfer tax to have the property or some kind of estate put into their name, or some knowledge to the public that they have an interest in the property. Joe?
If, like we said earlier, you remember the case where a mortgage was put down before the lease purchase was put down on the records, and it's a first come first served system, basically. So let's suppose that you get a lease purchase that gives you a leasehold estate. You have an interest in that property, and you have an option, which is also an interest in the property of a sort. It's a right.
Future right.
Yeah, future right. Yeah, but if you don't record your lease and the landlord goes out and mortgages it later, that mortgage is ahead of you. You're not even recorded yet. Even if you find out about it, you run to the registrar's office and record your lease, he'll be ahead of you. So a lot of, for example, there's another instance. Let us suppose that your landlord sells the property. If he sells the property to somebody else and you don't have a lease down on record, you can be dispossessed by that new guy. Now, the landlord may have breached his covenant of quiet possession, but you could lose your lease and your option in that case. But if you are of record, your lease and your right to purchase are ahead of the guy that bought it. So he takes that property subject to your lease. He has to honor it, and he has to honor your right to purchase that property, both being interests in land. So if you've got a contract to purchase and an option, you would still record that, because the option itself is an interest in the land, and an option recorded ahead of a sale would predate that sale, so that the guy that bought it would have to take that property subject to your right to purchase it at a certain price at a later date. It wouldn't help you on the contract side very much, because again, that's not an interest in land. So.
Okay, thanks. I have a follow-up question, or another question. Do you have any idea what percentage of these lease purchase kinds of contracts are done by mom and pop shops versus out-of-town corporations?
Yeah, that's a question of who the rent investor is. The guys that go out, there are a lot of local guys that go out and buy land and rent it, and it's they do it just like, and on some of those, they have an option to purchase. But I'm going to defer to Mike on this because he knows a lot more about it.
To answer that question, back in the 5 years ago, a lot of companies came in and they did use the lease purchase option and the rent to own and all those kind of things. But what happened there was they could not take those off. Then they would have a 50 house or 100 houses they wanted to get financed on the stock market, and none of the big banks would take any kind of properties with lease purchase or on lease purchase or right to own or right to contract or build. Any of those things would knock a property out of a package.
Mm-hmm.
So the large, big people that are buying properties, corporations have since all run away from that model. So I would say that the ones that you have might be from maybe a local investor, maybe that's doing maybe getting a little bit bigger, maybe 10, 15, 20 in a year. And I don't even know who that would be, but that's where your most would come from. Other than that, you see a lot of little guys buying houses, and that's one of the ways they try to sell them, because they bought these houses in really hard areas, and they don't really have a good idea of how to, once they figure out what it's going to cost them, then a real estate agent or one of these wholesalers approaches them with an idea, and that's how a lot of these deals come to happen.
What happens is the big on Wall Street, the big guys that buy all of these up are generally real estate investment trusts, and almost all of them are, as a matter of fact. They can only make money from rent. They can't make money selling houses, and that invalidates their REIT status. So they're not interested in that. So a lot of the guys who want to feed to a REIT won't put an option to purchase in any contract at all.
Okay, thank you. Any additional questions from the community out there watching? Before we sort of wrap up, would our legal team or our CDC team in Charia like to add any closing remarks?
Catherine, this is Daphne.
Sure.
So could we give code enforcement, I'm Daphne McPherson from the Hooks Institute, by the way. Could we give code enforcement referrals for renters they may come across who may need legal assistance in determining what kind of arrangement they're in?
Sure. First of all, we'll share a document with code enforcement staff after this, but there are a couple of places that people can go for assistance, and Charia can jump in here if I forget somebody. But Memphis Area Legal Services can assist with these types of contracts. Additionally, HUD certified counselors for instance, at Frayser CDC, or and there are several others in town who can assist. So those are places that you could, that code enforcement officers could absolutely make referrals to homeowners that they find that might be in these contracts. Charia, would you like to add anything to that?
No, you hit it. You hit it on the head.
Okay, so we will share those resources after the panel is over. So Daphne, would you like to wrap us up?
Yes, I will. I'd also like to volunteer one additional source, which I think is Apperson Crump. Is that correct? So in our lab,
actually have a little team that works on those. So if they need to come up here, we always let them come in and make the initial, visit free and see where we need to go with them. And yeah, absolutely, we'd love to help and be one of the players in your project.
Yeah, I think that's wonderful. I mean, initial consultation to at least let
sure.
the renters know what, in fact, the legal document they in is. And then after that, they can discuss that further with the attorneys about what their options are. So first of all, I'd like to thank our attorneys for this pro bono commitment today. Between the October 16th and today, we've had the privilege of speaking to 78 staff people of the City of Memphis Code Enforcement. I'd also like to thank Charia and the CDCs for their cooperation in working with the Hooks Institute and the University of Memphis on this issue, which impacts, as you imagine, those who are at the margins of society, and those who need the least should be taken advantage of the least, because life for them has been the hardest. And I think that's what's so egregious about these agreements. The fact that, human nature such as it is, we take advantage of, not we, but people take advantage of people who need the most help. And finally, I'd like to extend my gratitude to the School of Public Policy and Urban Affairs and its director, Catherine Lambert-Pennington, for working with the Hooks Institute on this. The Hooks Institute and SUEP are trying to still determine the scope of this problem. And it's not an easy task because as Mr. Aldridge and Mr. Fernley said, one, these lease to purchase agreements are rarely recorded or they're difficult to find. And also people in them don't recognize what they're in. So the people who come in contact with them first will be people from code enforcement many times. So we hope that this training in some way has prepared you. Obviously, you have to do your job, but as we are all each other's brothers in this world, struggling to survive, that you all will make the appropriate referrals for people you encounter to appropriate legal services for assistance. So our time is up, and we thank you for yours, and we hope that we can be of assistance to you in the future. Thank you.